Hello, my name's Phil Sayers. I'm an employment solicitor with Norders LLP based in Truro, Cornwall. Firm covers all areas of law, so please let me know if I can help with anything. But today I'm here to talk to you about restrictive covenants in employment contracts. Without further ado, what are restrictive covenants? In a nutshell, they're contractual provisions which restrict, for a period of time, the ability of a departed employee to compete with their former employer. Although we are primarily concerned with such restrictions contained in employment contracts, similar provisions are also often contained in other documents, such as partnership agreements and agreements relating to the sale of businesses. That will generally be the seller agreeing not to start a new business, which is competitive with the one they've just sold to the buyer. In addition to the usual restrictive covenants that we shall be discussing today, there are clauses and remuneration schemes known as atypical restraints of trade. Examples include deferred payment of bonuses and training cost clawback provisions. Such atypical restrictive covenants are sometimes challenged by employees, arguing that they are an impermissible deterrent to leaving their employer to join another business. Why have restrictive covenants? Well, former employees are often in a position to take advantage of knowledge they've gained about commercially sensitive information relating to their former employer, and likewise the connections they've made with customers and colleagues. They could potentially use that knowledge and those connections to assist a new employer, or to set up a new business which would then be harmful to their former employer, due to customers taking their customer away, or further employees departing at the behest of their former colleague. Although employees, while in employment, are subject to implied duties, such as a duty not to compete with their employer and not to make improper use of confidential information, those implied duties do not generally survive the termination of employment. There is a narrow exception regarding trade secrets. That only relates to things like inventions and formulas, rather than commercially sensitive information more broadly. By way of simple example, an employee could not, as a matter of implied UK law, leave Coca-Cola to join Pepsi and say, well, this is how they make the drink, because that recipe would be a protected trade secret. They probably could, however, leave Coca-Cola to join Pepsi and inform them of Coca-Cola's outline market forecasts, because that information would be commercially sensitive, but hard to properly categorise as a trade secret. Such situations are where contractually agreed post-termination confidentiality obligations and restrictive covenants can cover the lack of protection afforded by the law itself. The effect of a contractual obligation to keep confidential information confidential after employment ends is of uncertain legal standing, as there is contradictory case law. It is unclear whether that can be effective with regards to information which cannot be categorised as a trade secret. This is part of the reason many employers also seek to impose restrictive covenants on departing employees.